Welcome to CEU Democracy Institute, ladies and gentlemen. Warm greetings from Budapest. And I am absolutely delighted to present Judge Rossi to you, who is a professor at Bologna, but most importantly, who represents Italy on the Court of Justice of the European Union. And of course, you will know her not only as a juge rapporteur in crucial cases, but also as an academic who has written extensively on values, especially her recent paper on les valeurs juridiques des valeurs has been cited extensively all around Europe, and given the prominence of the rule of law issues in the case law of the Court of Justice today, this is definitely one of the most fundamental topics to address. So, of course, there is an asterisk. I have to mention that as a sitting judge, we cannot expect Judge Rossi to respond to any kind of questions that concern pending cases. But of course, as an academic, also cited recently by the Advocate General, that paper I just mentioned, Judge Rossi will give us a broad overview of the state of affairs in the rule of law field in the European Union. And as a commentator, following Judge Rossi's lecture, we will have Dr. Barbara Grabowska-Moroz, who is a fellow here at CEU Democracy Institute in Budapest, and who has had a distinguished career as well. Of course, a shorter career, but let's say as promising, which means that my delight is basically doubled to welcome two amazing ladies to Budapest today, even if only virtually due to our COVID restrictions. So, Judge Rossi, the floor is yours.
Thank you so much, dear Dimitry. I'm sorry not to have been able to come to the beautiful city of Budapest, but now because of COVID and because of a lot of work, it's a pleasure anyway. I'm happy to connect by video. I will deliver quite an academic speech, I think, and of course, nothing of what I'm saying is going to engage the court. This is just personal opinions. I would like to analyze with you this topic of the values, the value of the values in the European Union law. First of all, values, principle, rights. We, at the beginning of the process of integration, already knew that the European community, European Economic Community, European Community, and now the European Union deliver rights to individuals. And the Charter of Fundamental Rights is, I mean, the final coronation of this process of granting rights to individuals, a process that started with the Van Genden laws, when the Court of Justice in 1963 said that this particular legal law, this particular international treaty is able to grant rights to individuals. So the category of rights is quite known, not only among the specialists of European Union law, but I think also among the citizens of the Union. What about the principle? Because we sometimes speak of rights, sometimes of principles, and sometimes of values. This is a principle is quite a fuzzy category, because is a generic term, if you want. We have very fundamental and structural principle like direct effect or primacy of EU law. Then we have more, less structural and more detailed, less general, more detailed principle. For instance, in the environmental law, the responsibility of the polluter that must pay. This is a principle. And all these principles can have a different value. Structural principles are the essence of the social contract of EU law, And they are also based on the founded on the principle of loyal cooperation, that is probably the principle that resumes all the principle pertaining to the relation between the EU and the member states. But we also have the principle in the meaning of Article 52.5 of the Charter of Fundamental Rights, saying that the provision of the Charter, which contain principle, may be implemented by legislative and executive acts of the institutions of the Union and by acts of the member states when they are implementing Union law in their exercise of their respective power. Article 52 is point 5 is of course only referred to some provision of the Charter that contain principle and not rights, and with reference to those principles, Article 52.5 says that those principles shall be judicially cognizable only in the interpretation of the acts adopted and the ruling of their legality. So you see, when we speak of principle, we speak of very, very broad and not uniform category. But at the beginning, the values of we are going to speak today were considered the principle. At the beginning, I would just want to make a short, very brief, short synthesis of the evolution of this concept of principle and today of values. Today, if we look behind, it seems very extraordinary that we can speak at EU level of values. The process of European integration passed from the Europe of markets to Europe of the rights and principle, and now is an Europe of values. We are just at the beginning of a process, and there are some conflicts. We are going to speak of that at the end, because when you deal with values, there are many different points of view in the national constitutions in the EU. It's not always easy to make a synthesis, but as we are going to see, there are some values so fundamental that should not be questioned by nor by the institution, neither by the institution nor by the member states. So the Treaty of Maastricht in Article F stated that the Union respects the national traditions of the member states whose systems of government are founded on the principle of democracy. That was the first time, not in a preamble, but in a very, hard provision of the treaty, primary law, the first time that a close link was established between the national tradition and the rule of law. The Treaty of Amsterdam modified Article F, introducing Article F1 with the mechanism today provided for by Article 7(1) TEU. And at the time of the Treaty of Amsterdam, it was stated that the Union is founded on the principle of freedom, democracy, respect for the human rights and fundamental freedoms, rule of law, with the formulation which is almost the same of what today Article 2 TEU states. So in this same article F in the Amsterdam version was also introduced the concept of identity of member states, saying that the Union must respect the national identity of the member states. So that was the beginning of this connection between the values, the time principle, were defined and labeled as principle, and the national identities. In the same terms, all has been moved to the Article 6 TU by the Treaty of Nice. And then it is the Treaty of Lisbon that reframes all this concept in what it is, in my opinion, a very clear framework. Article 2 TU with the Treaty of Lisbon is now richer and more complex than the provision that we examine so far. Article 2 now speaks of values, and these values are the supreme values which are connected, strictly connected with the very essence of the membership. Why that? Because you can only become member if you respect some fundamental values, which are notably illustrated by the so-called Copenhagen criteria. And there is a process during which the Commission assess if the candidate states offers guarantees to respect those core values of the EU. So these are today the core values of the membership. You may read the list in Article 2. I'm sure that you already know this list very well. We can say that those articles are not only fundamental values, but also foundational values of the European Union. So Article 2 is really a constitutional provision of the EU legal system. Those values are so important that particular procedure have been established by Article 7 TU. We saw that first approach in this sense, first tentative in this sense was made by the previous treaty, in the Treaty of Amsterdam, notably. We already know that the mechanism of Article 7, above all the second part of Article 7, are almost impossible to put in place. All the academics call them the atomic bombs, deterrent effect maybe, effective use no, because requiring the unanimity of all the other states involved but the state concerned. It is almost impossible to use. Not impossible to use the first part of the mechanism of Article 7, the early warning, but very, very difficult to arrive to the unanimity of all the other member states required by the second part of Article 7 TU. But those values are so important that we cannot imagine, this is my opinion, but not only my opinion, could we imagine that for the protection of those so foundational and fundamental and important values, the only weapon, the only remedy is Article 7 TU? It would, if we admit, if we would admit that, well, every other provision, principle, value of the treaty would be better protected. So we can only assume, this is logic, in my opinion, that Article 7 mechanism just add to the existing other remedies for the violation of EU law. In fact, Article 269 for the infringement procedures only limits the review of the acts adopted pursuant to Article 7 TU, not all the what is related to Article 2. This is an important statement, and it's also a personal opinion. I'm aware that can be strange, but it is just, in my opinion, a matter of logic. As Dimitry mentioned, our court is now delivering many judgments about what is the value of Article 2, notably with respect to the rule of law. But it's not just in the last years. For instance, in Opinion 213, the court said that the member states share common values and the link between common values and mutual trust was clearly illustrated by this opinion. And also in Opinion 117, the court noted that the values of Article 2 TU are a part of the constitutional framework of the European Union. So we can say on the basis of all this case law that Article 2 is probably at the very core of the European constitutional identity. This is also confirmed by the preamble of the Charter, for instance. But now let's try to put Article 2 and its value in context. Notably, let's try to make an assessment of the relations between Article 2 and other provisions of the treaty. The first step the court made was illustrating the link between Article 2 and Article 19 TU in Portuguese, in the case of Portuguese judges, 2018. And in that case, the court said that Article 19 is an expression of Article 2. And the independence of the national judges is necessary for the proper functioning of all the judicial system of the European Union. Of course, as you know, the mechanism of preliminary reference requires independent judges. So this is why Article 19 is so important and the independence of judges is so important in the EU legal system, and that's probably also the reason because it was with reference to rule of law in general and the independence of judges, of national judges in particular, that Article 2 was raised in such a strong way for the first time with reference to Article 19 TU. But also in the legislation of the European Union, for instance, for the European arrest warrant, there is a clear link between respect of the rule of law, respect of the values of Article 2, mutual trust, and the possibility to execute a European arrest warrant. If you read the framework decision on a European arrest warrant, you see that there are different consequences which are strictly mirroring the progress of a procedure pursuant to Article 7 TU, the early warning or the eventual sanction, and these different steps also imply different degree of suspension, possibility of suspend the European arrest warrant, or even the interdiction to execute an European arrest warrant. So there is really a strict link between the mutual trust among the member states and the respect of the values of Article 2, and notably in this case of the independence of judges. And this is also, I don't want today to speak of the many cases that the court already decided about the judicial independence or the cases that are going to be decided in the next month. Just let me mention the last one, which is EIS, just a few days ago. But this is, I mean, the same line of reasoning of Portuguese judges, if you want, that the EU needs to rely, the other member states need to rely to a system into every member state that works with the respects the principles and the values, and notably the rule of law and the independence of judiciary. What is interesting, in my opinion, is also the relation between Article 2 and Article 49. And here I will briefly mention this judgment Repubblica of April of this year. Article 49 is the provision in the treaty that describes the process of accession of a new member state. Article 49 imposes some condition for the member states, for the candidates that voluntarily want to accede to EU. So it is clear that if a candidate state wants to be a member of the Union, enter the club, must comply with the values of Article 2. Before saying something about Repubblica, the Maltese judge's case, I just want to reflect with you that it's not so strange that there is such a strict connection between values and accession to the European Union. It has always been the same. When the new member state, when the candidate become a new member state, they also embrace a complex of values. For the founding states, the six first founding member states, the acceding founding the Union in their case was a pacification between winners and losers in the war. Take then the case of Greece, Spain, and Portugal. For them, acceding the EU meant to exit from dictatorships. With the the great enlargement of 2004, many countries of the Eastern Europe left a system, left also an ideological system, but also they left the Cold War, and above all, they put themselves in a safe sphere of influence, leaving the sphere of influence of Russia. I'm sure that if some member states that maybe today are very critical against the European Union, if they didn't accede, they would be today probably as Ukraine, that is the states that are rich of history, rich of values, rich of constitutional tradition, but very weak and very exposed to the influence of other very powerful neighbors. So take also the case, for instance, of Slovenia and Croatia. For them, acceding the Union was again embracing a set of values and also pacificating after a very cruel war. For Cyprus, the accession is also a a way for escaping the influence of Turkey. Then we could speak of Ireland. Ireland, the European integration, participating to the EU, help Ireland to pacificate the civil war between the two islands. If you ask me what was the value inducing UK to accede, I don't know. Maybe it was a way for controlling from inside instead of from outside, a process of integration of the European continent that they probably deemed contrary to their national interest. But we saw how was the end of this participation, of this membership. Not a very, strong reason for entering, probably, not reason not strong enough to remain. So let's go back to this case, this judgment of the Court of Justice, Repubblica. In this case, in this judgment, it is clearly established the link between Article 49 and Article 2 TU. In appeals, very, very shortly, from one side, the Union is clearly founded on values such as the rule of law. And on the other side, the member states acceding candidates are not, not unaware, not conscious that there is this set of values. And when they voluntarily accede to the Union, also they accept to embrace this value. And this is very clear because of the procedure of accession, which, as I said before, is founded on the checks and controls by the Commission that they respect those values. So the idea is that these values are connected to the membership. Not only when you enter the European Union, you state, but they are the condition, this judgment says, the condition for enjoying all the rights granted by the EU membership. So it's a condition. This judgment was referred in the case to judicial independence, but it is formulated in quite general terms, so we can imagine that also other values of Article 2 could be, to other values of Article 2, the same reasoning could be applied. Also, it is interesting to, with this connection between Article 49 and Article 2, the idea, the concept of rule of law that emerges, because of course, what is the rule of law? There could be different, different, more or less detailed description, but at least in this case, in this judgment, it is clear that as far as the membership is connected, the rule of law, the value of rule of law is the level, the threshold is the threshold that must be respected when you accede. So the Copenhagen criteria, and this judgment establishes in fact the principle of non-regression. If you respect a certain degree of values of a rule of law, you cannot go back, you cannot go under this threshold after you accede, because this is a violation of the core values of the membership. Now, it's also important to put Article 2 in context. Notably, what are the relations between Article 2 and Article 4.2, but Article 4 in general, TU, and what are the relations between Article 2 and Article 6 TU. All these relations show how more complex and interesting is the system, the constitutional system established by the Treaty of Lisbon. We saw before that all these concept of this idea were packed in only provision, Article F1 with the Treaty of Amsterdam. Now, these values, this principle are much more clearly established by the Treaty of Lisbon. Let's take the Article 4. Article 4 itself must be put in context. When we think to Article 4, paragraph 2, the first idea is that, if you read it, yes, the European Union must respect the national constitutional identity of the member states. True, but we must always remember that Article 4 also establishes other fundamental principles that are put on the same value of the respect for national constitutional identity, notably the principle of conferral, the principle of equality of the member states before the law, which is quite not a contradiction, but a strong alter ego of the respect of national constitutional identity. And at the end, also the principle of loyal cooperation. This is the context of Article 4 TU, and all these principles are connected, and I stress again, are all on the same ground. So what are the national constitutional identity? And this is a very, fashionable theoretical problem in the academic research. What is the content of national constitutional identity, and can the national constitutional identity derogate to the values established by Article 2? This is a question, and the answer is that, of course, national constitutional identity is also in the system quite a new concept, which is stronger than the old, still present Article 6 TU concept of common constitutional tradition. Why? Because common constitutional tradition are a category entirely created by the Court of Justice, and when you say common constitutional tradition, you must stress the word common. So it is up to the court to decide if it was, and it is, if a constitutional tradition which is invoked by a member state in order to derogate the common rules is common. Common is not an exercise of comparative law. This constitutional tradition must not be present in all the member states, but is nevertheless, an assessment and evaluation that pertains to belongs to the Court of Justice. The concept of national constitutional identity is stronger than common constitutional tradition, because, of course, when the court say what the common constitutional tradition is, the court can in a certain way create, harmonize different tradition. But national constitutional identity is something that only the national constitutions, the national constitutional court can define. So Article 4.2 establishes a sort of two steps procedure. It is up to the Nation Constitutional Court to define what the nation constitutional identity, but then the second step is that it is up to the Court of Justice to accept or not this nation constitutional identity, which is peculiar to the member state, as a reason for derogating the other principle of Article 4, that is that all the member states are equal before the law. And if we take the case law about nation constitutional identity, I mean the case where the nation constitutional identity was invoked, we see that at the beginning, these elements of nation constitutional identity was not much more than the traditional concept of mandatory requirements, that is something that a state invokes in order to derogate to the common rule. Just some examples: titles of nobility, Sein Wittgenstein, Bogendorf, the nationality for as a condition for the notary commission versus Luxembourg, the national rules of written the names or surnames, Runevich. There are many cases where the national constitutional identity was invoked, but for instance, the new cases, for instance, BK of July of this year, BK, is now something that is not more anymore similar to a mandatory requirement. In BK, the state was invoking and successfully invoking the concept that military activities is something pertaining to the national constitutional identity, and it is expressly protected by Article 4.2 TU. So Article 4 can justify some derogation, Article 4.2, but I don't think that Article 4.2 can be invoked for derogation of the values established by Article 2, because Article 2 is really a top provision, a top set of values. So a state cannot invoke the national constitutional identity just to put to question, to put in discussion the very essence of the membership. Of course, a constitutional court maybe can say this part of the EU law is against my national constitutional identity. But if this part of the EU law is the rule of law, is part of the values of Article 2, then it is the membership that is put in the stake. The membership itself, the state, if really finds that there is a contradiction between values of Article 2 and the national constitutional identity, can modify the constitution or can exit, because it is the membership itself that is no more justified. Of course, they could also try to modify the treaties if they find the unanimity because of all the other states, because as you know, only with the unanimity of all the member states and the ratification of all the national parliaments, the treaty can be modified. So this third way is also a possibility, but not very easy to reach. Is not, I think, today very likewise that all the other member states are set to make a step back with the values of Article 2. Everything is possible, of course, but I don't say. In any case, the Court of Justice absolutely doesn't want to expand its power, as someone says. The Court of Justice is subject to the treaty and must respect. So the role of the court is to respect the existing treaty, the existing set of values. Insofar as the values are not changed by the new treaty, the court must stick with it, must protect them. Then the last relation that I would like to explore, the relation between Article 2 and Article 6 TU, because both Article 2 and Article 6 mention the fundamental rights. In my opinion, there is a difference because Article 6, as well as the Charter of Fundamental Rights, deal with the rights of individual and in the specific case. Why, when we speak of fundamental rights in the light of Article 2, this is again a personal opinion. I'm not sure that all my colleague would share this position, but in my opinion, I read Article 2 as covering the systemic dimension. There is also other professors saying the same. It's not, I mean, I'm not the only one thinking that, but why it can be, in my opinion, Article 2 can be considered as just covering the systemic dimension, because Article 2 itself in its text makes reference to the society of the member states. So that could be a difference between Article 2 and Article 6 TU. As far as fundamental rights are concerned, it is of course something which is theoretical and academic, but can be interesting. And we could speak for a long time of the Charter and the approach, the different approach of the Charter of Article 2 towards, for instance, the national constitutions, because also the Charter speaks of the common constitutional tradition, Article 52.4, but only says that the Charter must be interpreted in harmony with the common constitutional tradition, and also Article 53 that mentioned the national constitution as a minimum standard of protection. The court and the constitution, the Court of Justice and Constitutional Court of Member States often are involved in a dialogue about the minimum threshold of fundamental rights. There has been, from one side, for instance, Meloni, where the court said that when there is an harmonization of a certain field of law, the state cannot invoke the national threshold of fundamental rights to derogate, but there are also cases like NAS MB, the Tarico 2 case, in which the Court of Justice accepted the perspective of the Italian Constitutional Court that was able to show that there was really a problem, a constitutional problem of minimum standard of certain fundamental rights. So this brings me at the end of my presentation, I would like just to say some words about this alternative that I see in the relations between the Court of Justice and the national constitutional or supreme courts of the member states. The alternative is the dialogue or the conflict. You know, many dozen of years ago in Kreil, the court said that the national provision, even of constitutional level, cannot prevail on the EU law. But now the framework is much more complex. We have seen this concept of nation constitutional identities that probably tries to incorporate the traditional theory of the counter limits, a theory created by the nation constitutional courts, for instance, the Italian and the German, were the first constitutional courts developing this concept of counter limits. And now there are several cases of nation constitutional court that with different approach try to sometimes to refuse the primacy of EU law. I don't want to discuss it too much in detail, but there are a sort of bilateral adjustment. For instance, if you take the case of Germany, after the first judgment Weiss, then now the German Constitutional Court said that everything is okay, that the explanation of the European Central Bank are sufficient, so they do not context anymore the outright monetary transaction and this particular specific operation put in place by the ECB. In Romania, there is just a recent field of, not convergence after the judgment Quadrature du Net of the Court of Justice. The Romanian Constitutional Court refused this approach of the court, but the court has stated again with even more strength in the case Associatia. The French Constitutional Court in the case Air France very recently, October 15 of this year, said that if a provision of the European Union law with direct effect, that is not only regulation but also certain directives, if those provision doesn't impinge with the nation constitutional identity, the Conseil d'État is not competent to verify, to check, to assess the compatibility with the constitution from the French constitution of a provision of the French law that just implement the EU law. So it is a way of circumscribing its own power. It can be seen from one side as an act of self-restraint of the French Constitutional Court, but on the other side also the court is reserving this very new and friendly approach only when the nation's identity is not at the stake. I don't want to say nothing on the Polish case because we are probably having some cases at the court. I just can agree with a part of the doctrine that underlines how this refuse of the Polish Constitutional Court goes much beyond the other cases that we have mentioned, because it's very general, it's not connected to a particular rule, particular provision of the EU legislation. But we still don't have the full text of this judgment in a language that I can read, so I don't want, this is even one more reason not to speak about this judgment. But at the end of the day, there must be a cooperation, a dialogue between the constitutional courts of the member states and the Court of Justice. in case there is, in case the Constitutional Court think that there is a real problem, the best thing is to make a preliminary reference to the Court of Justice, so that not only the Court of Justice, but even maybe other member states can intervene, and the problem can be discussed before the court, I mean, in a public hearing, and everything can be assessed and valued. So this is the end of my presentation, and maybe you have some question. I'm not sure I can answer to all your questions, not only because of time, but also because as a judge, I don't want to speak of pending cases. So, okay.
Thank you, Judge Rossi. Thank you for your speech. I think it was really excellent overview of all the topics we are working on right now at the CEU Democracy Institute. I mean, I think it's a great picture to start a really interesting discussion about values in the EU. A footnote for our audience: you can still ask questions in the comment section on Facebook when our webinar is live streamed. And I had a feeling right now that we fully agree with you, Professor Judge Rossi, since together with Dimitry and Kim Lane-Shepele, we wrote in a huge paper published about a year ago that EU values are law after all. And as you mentioned in your speech, Article 2 can be given a very clear normative meaning, which I think is absolutely a crucial point, exactly to those, when you look at those hard cases, which you mentioned in the very end of your speech, with Romanian case, with the Polish example. I don't want to discuss this Polish case, even though I'm really much interested in it, but because we don't have the written reasoning of the court, one of the sentence in this press release, I think it's really disturbing, because it says Article 2 are not legal principles. This is what was written, at least in the press release, which I think might be very worrisome if we think about looking for space for judicial dialogue. But since we're in the dialogue section, I want to ask you about a dialogue with another court, with Strasbourg Court. As you probably saw, there were a couple of cases decided in Polish cases, in fact, dealing with the status of the highest court, status of the newly appointed judges, and couple of them, I think there were at least 3 of them, they fully refer to the case law of the Court of Justice. And to some extent, they also base on it when they provide and they issue the decision that there was a violation of European Convention on Human Rights. Would you like to comment on that? How can you see how the Strasbourg Court uses the interpretation of EU values from Luxembourg Court? Can you see any interesting connections with the CEU case law?
Well, thanks for this question. First of all, I just see that we had the communiqué de presse, press release, that on November 24, the Polish Constitutional Court said that Article 6 of the Convention, the European Convention, is incompatible with the Constitution, the nation Constitution. So this is, I mean, maybe the beginning of another series of problems between the the Polish Constitutional Court and the other court, the other European Court of Strasbourg. In this case, it is focalized on Article 6 in the European Convention. In the case, in the judgment about the EU law is more general, if I understand well the press release, generally focused on the primacy, so it's even more systemic again challenge. Of course, the 2 courts are in contact. They are usually in contact not just for Poland, not just for rule of law. We met twice per year, and we discuss the comparative, in a comparative way, the European Union and the conventional approaches to the single rights. Of course, now we have been, with the court, have been both challenged, if you want, by these judgments of the Polish Constitutional Court. Of course, the scope of our court is different, but as you said, there is a parallelism. I see a parallelism between many, not only between the challenges, but also between the answers that our respective courts can deliver.
Dimitry, do you have any questions?
Yes, in fact, I absolutely adored your talk, Professor Rossi, and it goes along the lines that plenty of colleagues and friends would fully subscribe to. So it's a delight that there is an emerging understanding of how different articles of the treaties and the charter hang together in helping us to safeguard the rule of law, especially. I find your reference to the hierarchy between Article 2 and Article 4 deeply convincing, because to interpret a particular part of Article 4 as an opportunity given to the member states to turn their back to the most basic conditions which they had to accept when they joined the union, it seems to me absolutely illogical, deep and deeply worrisome, in fact, if someone would find this the way to go. And in this light, and also inspired by Professor Sadurski's scholarship especially, I have a question, and that is, it seems like Central and Eastern European states were actually guided by the star of a safe space of the European Union. And you referred yourself to the safe sphere of influence of the European Union, the sane space of law, human rights protection, and the protection of values when they submitted the applications to join. So Professor Sadursky teaches us this is exactly one of the core motivations to accede. So in this sense, you are in full agreement. And the question is, beyond the Court of Justice, do you think do you think the European Union is delivering on this promise of providing this safe space? And I'm asking this question especially in the light of what's going on in the Polish Republic today. If it's clear that the national authorities are turning back, are turning away from Article 2, if Article 4 is interpreted as a way to trump the obligations of membership, then what else could the union do, and is the union doing enough?
The relation about the relation between Article 2 and Article 4 and 6, I wrote some years ago in the Studi Tizzano, the book in the honor of Antonio Tizzano. An article whose title is 246 TU, but it is in Italian, so I'm not expecting that everybody can read Italian. But I wrote this article before becoming a judge, so I was very free of mind that no responsibility as a judge at that time. You ask me if the European Union provides, delivers sufficiently. Well, this cannot be asked to a judge of the European Union, because that should be asked to the legislators to the European Union. What the judges can do is just to make the existing body of EU law and rights respected. This is my answer as a judge.
We have another question from Facebook, and that would deal with cooperation between the national domestic courts and the CJEU. Are there other mechanisms of cooperation additional to prejudicial procedure, so preliminary reference?
Well, of course, there is the infringement procedures, and if I'm not wrong, Poland is paying €1 million per day. So infringement procedure is can be very effective. 1 million euros per day seems to normal citizen an enormous amount of money, which is not necessarily an enormous amount of money for a state, but it is quite a penalty. Then there are other mechanisms which are just under the review of the court, so I'm not going to speak about the conditionality regulation. This is something that we have still to assess.
We have another question, this time for Dimitry again, please.
Building on what you, Barbara, asked, the cooperation between the Court of Justice and the European Court of Human Rights. We heard from the European Court of Human Rights that there can be no hesitation under Article 6, and this is precisely why the Constitutional Court of Poland, so-called, is now attacking Article 6 CCHR as well, not only EU law, that the court that we are talking about is not actually a court, as its composition is not lawful as interpreted under the convention. So in this sense, my question is, given the faithful atmosphere of cooperation between the two highest courts of the European continent, how far would you consider the Court of Justice bound by the view or inspired by the view that that is expressed by the Court of Human Rights? I noticed that in your lecture you referred to the Polish judiciary, which is considered hijacked by the Court of Human Rights as courts. Something that the most notable commentators, for instance, Professor Laurent Pech, would always say, adding a kangaroo court, making a reference to US, old US case law from the 19th century. So are you guided by the CHR in treating a kangaroo court as a kangaroo court, or will you have a different approach to this issue?
Well, I just want to remind that the Charter of Fundamental Rights sets the European Convention as a minimum standard. So we usually, of course, are bound when we apply the Charter not to go under the threshold of the case law of the European Convention. Of course, this is theoretically just for the Charter, but the Charter applies to in the scope of EU law. We of course think that what the European Court, the Strasbourg Court is making is very useful for us because they are a specialized court on fundamental rights. The big difference is that they deal with individual rights in individual cases, while we have a more, again, systemic approach. We have fundamental rights as a part of a European constitution, as if you not European constitution, I mean informal sense, but of European, let's say, constitutional system. So fundamental rights are part of that. When we speak of individuals, we use the standards of the European Convention, but first of all, it must be noted that we use those standards not against the member states, but first of all, against the institution of EU law. If they don't respect the values, the fundamental rights as established also by the Strasbourg Court, an act of the EU institution can be validated, can be annulled, can be declared as invalid. So, of course, member states, the translation of, the passage from Strasbourg to Luxembourg, as far as the member states of the EU are concerned, pass through the application of EU law, in the scope of application when they implement EU law. So it is a different perspective. It's not just that even if the rights are the same, even we are absolutely ready and happy to respect the threshold established in Strasbourg. The context in which this provision, which are very similar sometimes in the Charter and the European Convention, can apply is different. So that can be my answer.
I would like to refer to one of your basic statement when you said that Article 2 is basically a basic constitutional framework of the EU, and by that it creates EU constitutional identity. And I was wondering, bearing in mind that, you know, justice needs to be seen to be done, do you think it would be a good idea for the EU values so that the hearings of the Court of Justice would be streamed online? And I'm asking not only as academic, but basically as an EU citizen. So because of the role of the Court of Justice rulings, I have a feeling that the process of constitutionalization of the Court of Justice has already happened. And as a citizens, we can see the effects of that. Do you think there is a space for live streaming, and that there is chance for that?
There sure is a space, and we have quite often television broadcasting our sittings, our hearings. We have technical problems, not ideological problems. For instance, one of the problems is the translation, because we work in one language. But there is translation in all the languages of the 23 official languages, but we are not able to broadcast in 23 different, the translation. This is the problem. Okay. So we have really technical problems that have been also aggravated by the COVID. Because with the COVID, we have now some states that prefer to speak at distance. Not they don't come in the room, they speak at distance. So there are a lot of these little but really big problem. And what is difficult to understand from the outside is this fact that if we have to, we are not at the moment able to broadcast the translations that we have. The translation in our, but not we have no channel enough. Probably it would be wise to maybe establish a way that allows, in cases that are considered particularly interesting, to facilitate the procedure for someone asking. But I repeat, I see I see the cameras, so I don't know where they are broadcasting, in what states. I suppose the state of the procedure, not in all the member states.
We have one more question, this time from Petra Bart, as a follow-up to Dimitry's previous question, and that is, how far could the CJEU take into account the Bivolaru and Moldovan case of the European Court of Human Rights, rebutting the Bosphorus presumption in cases involving mutual recognition?
Well, this is a long, a long debate. There have been different not only one, at least 3 judgments of the Strasbourg Court on this topic of mutual recognition. It's not easy because mutual recognition is the backbone, for instance, of all the criminal EU law, European arrest warrant, but also is the very important for the judicial, civil judicial cooperation, not only criminal judicial cooperation. And the Court of Strasbourg said that they were not completely happy about our system. But I interpret this case law of the Court of Strasbourg as just an early warning. And in fact, they also, in Romero Castagno, they also said that it is part to the respect of European Convention to respect the EU law, and in this case to execute the European arrest warrant. So I don't think that there are very big and impossible to I mean, there is no big disagreement. There are different shadows, different aspects. I think that the problem was Meloni, but that was, I see this more an issue of the discretion that the EU law allows to the member states. Within that margin of appreciation, within that margin of appreciation left by a directive, by a framework decision, then it is important to see who does what. I mean, it is an infringement made by the member states implementing, it is an infringement of the European Convention made by the European law, European Union institution adopting a certain act. So there is this is something that must be assessed case by case. I also have to remind you that the European Union is not at the moment member of the European Convention. So at the end of the day, when the Court of Justice say we are due to respect the European Convention, the source of this obligation are Article 6 TU and Article 52 of the Charter. So internal sources, not external one.
We have one more question from Dimitry.
I apologize for abusing my presence here on the panel, but it's so extremely fascinating because when we speak about the crisis of the rule of law in the EU, of course we have our own courts in mind, the internal courts of the Union. But once you throw in the European Court of Human Rights, which is also our own court, then the picture is much more complicated. So my question relates to the intercourt dialogue in the context of the case law of the European Court of Human Rights. Could it be, and for now it seems like the European Court of Justice is very accommodating. It's trying to engage the courts at the member state level as much as possible, and it's very welcoming of the questions, right? So this is the backbone of EU law, as it were. This is the main feeding source of allowing the Court of Justice to formulate the principles. And now, if the case law of the European Court of Human Rights on what is a court and who is a lawful judge is taken fully on board by the Court of Justice, could this undermine this this vital dialogue between the member states courts and the supranational level? Meaning, could it be that at a certain point there will simply be no courts in the Polish Republic to talk to?
Well, I prefer to speak in a more abstract way. I repeat that there is, I think, a mutual inspiration between our courts. There is no competition. There is no fear of losing power. It is a mutual inspiration, and I said already, we meet twice per year. We look for a dialogue which is not, I mean, a formal dialogue, but a very substantial one. We discuss, and this is useful to see the different approaches. The different approaches are due not only to the fact that, of course, we are speaking of two different entities, the European Union and the system of the Strasbourg Convention, an international organization with more than 50 members, not all the members, there is no coincidence. But I find that in spite of all these differences, there is really a convergence which stems from a deep mutual interest in the solution adopted by the other court. I could speak of sister courts if you want.
We have one more question, this time from Facebook. I guess this will be the last one, but it's quite long. As I understand, you claim that it is a matter of simple logic that the values contained in Article 2 should be considered justiciable, citing the centrality of values criteria to accession under Article 49. However, how do you square this with the decision to expressly entrust responsibility over the procedures outlined in Article 7 and 49 to the political branches of the Union?
Mm-hmm. Well, as I said, why it is logic? Because if we assume that the values of Article 2 are the most important values of the EU legal system, it is, in my opinion, more logic to believe that the treaty, the system of the treaty provides an additional instrument to protect those values, that is Article 2, which adds to the other existing remedies. I wouldn't find very logic say that because we have Article 7 procedures, so all the others procedures, like for instance, infringement procedures, cannot be applied. This is something that would put the values of Article 2 in a weaker position in comparison that all the other values or principle or rights of the treaty. So of course, Article 2 is a set of values, and then we have to assess, specific question. Not we are today speaking an academic with academic approach. The approach of the judges of the courts is just to see what is at the stake in that case and what are the relations between different provisions of the treaty. I spoke of logic because if we would assume that the values of Article 2 could be protected only by means of Article 7, then we would consider that those articles are less protected. And it is more logical to say that because just because they are so important, those values of Article 2, there is an additional instrument to protect them. Article 7 established two different procedures, but they are additional.
We have one more question about the Republika ruling and the non-regression principle. I think we still have like 5 more minutes. So Judge Rossi, shall we proceed with this one? Is the non-regression rationale ultimately merely another way of ensuring member states' adherence to certain number of baseline requirements emanating from Article 2 values, and so to provide a novel justification to the current extent of enforcement? Or could it be possibly become an instrument to safeguard progress in the achievement of values more broadly, and thus to oversee potential regressions, even if they do not necessarily fall short of any baseline requirements?
Well, the principle of non-regression is just the basic threshold. Then there are maybe different instruments, different principles. It is the legislators, after all, that must go on with the values. It is up to the legislators, it's not up to the court itself to invent new rights or new values. I think that it is important to stress that if you want to become member states, nobody obliges you to become a member of the European Union. But if you want to enjoy, once you are a member, if you want to enjoy the rights of the EU membership, you must respect those values because you were admitted on the basis of those values.
Thank you, Judge Rossi. I think we reached the level when the new questions will be only increasing. So I think we should stop at this moment. Thank you so much for your time and for very inspiring speech. This was a part of the CUDI series of webinar, as a part also of a Reconnect project funded by the European Commission. All the streaming will be saved on and available on Facebook website of the CUDI. Judge Rossi, thank you very much again, and hopefully to see you soon again in other events of CUDI.
Thank you. Thank you to you, and I'm writing an article on this topic when it will be finished.
Wonderful. It's a great opportunity to meet again and to discuss the topic once again. Thank you so much.